An application by attorney Magdalene Moonsamy to conduct a watching brief for her client, Kelly Khumalo, in the Senzo Meyiwa murder trial was denied by the High Court in Pretoria today. Singer Khumalo is among several other witnesses that have been named in a second police docket submitted in court. Prosecution and defense lawyers for the accused are all objecting to Moonsamy's demand for access to documents on the trial, saying she could easily follow the proceedings on television. Now, earlier this year, she was asked to leave the court, with the presiding judge saying her presence will affect the purity of the case. Magdalene Moonsamy joins us now for her reaction. Magdalene, good evening. Thank you very much for your time and giving us this opportunity here on In Focus. The situation as it stands is that your particular situation, or at least the situation of your client, is particularly distinguished to a normal practice of watching brief, which is something that happens in our law, and nothing wrong with that. But it is different this time merely because your client might be, in fact, in the first instance, the prosecution saying will be called to testify, or client requested to testify, but later on saying might be called to testify. You can tell me what the technicalities are there. Good evening.
Hey Thabo, thank you and so much for having me. Firstly, let's start with the fact that there was an application, there was a confirmation from the senior, from Advocate Beloy, including the registrar, and a confirmation from the judges and counsel for accused 1 to 4 and 1 to 5 that I will be watching brief. Now, that has been undisputed. We are not affected by the current circumstances. Let me take you through the fact that there is a watching brief that has been sitting in court on behalf of whomever. And I am, as a watching brief of my client, denied. Huge discrepancy in terms of procedure, court procedure. Fine, well, let's move forward. Next point is the fact that we're dealing with a situation where we have been accused of testing the patience of the nation. Thabo, that is a subtle thread. It's agitation. Yeah. My client has been very cooperative. Yeah. Ours is not to be forced. We are not affected by our presence or absence in court. Yeah.
Who says you're testing the patience of the nation?
Mshalolo, Advocate Defense for 5. Did you not see that? Now, my point is, that is an agitation, it's a subtle thread. My client has been through extenuating circumstances. All we asked for, and you would know this, because I've been consistent, client has been consistent, we want our day in court.
Right.
So my issue is, we're not imposing ourselves on the judiciary. All we are saying is, give us access to court recordings. Yeah. Let me tell you, Thabo.
Well, hold on. Before we get to that, I'm going to give you a chance. I'm going to give you a chance to talk to that.
No. Let me put this to you before.
Yeah.
The manner in which this assumption has been placed to the media is that we want to be present, hana fish paste. All we ask for is access to the recordings, which is, in any event, public recordings. The reason we ask it is because we want to follow court processes, not because we want to hear it from ENCA or SABC or any other. We want it on the record. But it is being obfuscated to create a perception that we want to gain some kind of a status in court. Yeah. No. We want the recording which is an access in any way. Any public or citizen can have access to the court proceeding.
So on what grounds, for example, would I go to the court and say, I, Thabo Mdluli, want access to the record of the court, if I'm not party to any of the processes of the court? I'm not the complainant. I'm not currently a defendant. I'm not part of the processes. I might be called to come and testify, but even so, it would be best for me not to have that record, so that my testimony is not influenced in any way, so that I give true account. So, on what grounds? What would be the ground for me to want the access to the record?
The issue is that it is broadcasted. It is not a private in-camera hearing. It is publicly, it's internationally broadcast, minus that. As amicus curiae, you have access to want to hear what is the recordings of the court. You have access to it. There is no proceeding of the court that limits citizens. Any citizen has right to want to know what is the transpiring in a court proceeding. It is not limited. This is why we have an accountable, transparent system. Now let me tell you this. What is very precarious? Beloy says there is the watching brief of the Meyiwa family and other watching brief. But we refuse this watching brief. Now other defense says the prejudices on the accused we refuse. Uta, can I ask you, what prevents my client from having due and just process to access to nothing that is unfamiliar to what you know, what I know, but to the detail of the recording?
Yeah.
That is prejudice.
So there are two things there, Magdalene, and I want us to deal with them separately. No? One, let's talk about what you're raising. The other watching briefs, right? The other watching briefs, are they also going to be witnesses? Are they also going to be called to testify? Is their situation distinguishable in that similar way as your client?
I will be very exceptionally frank with you. We have spoken to Advocate Beloy, who contacted me regarding my client's status in the matter, sometime April-ish, before the trial commenced, and said, we want to consult with your client. We then arranged a time, and then Advocate Beloy said, there is no need for consultation because your client will not be a witness and is not a suspect. Mm. Now, subsequently, what transpires is beyond our understanding, because that is the word we communicate, and I will disclose that, the email to that effect, because we were then preparing for the process of going into consultation, preparing for trial.
Yeah.
And I was in court, you will recall. I was not removed permanently, and that is on the record. If Judge Mawumela and anyone else wants to dispute that, let's go back to the record when he says, you are temporarily recused and you will have access pending. So, no point were we then, prior to the point where my client was not a suspect or a witness, and we then requested, we are not playing with the patience of the nation as per what is being played out in the public domain in the state of intimidation, because that is subtle threat.
Yeah. Magdalene, why would you not, for example, as you put it, it's already in the public domain, and there are, for example, broadcasters who have this thing on archives. You could go to any of the broadcaster and say, can I request a tape, pay for it from their archives. Broadcasters do that all the time. Or if you like, you can go on the social network, YouTube, like all of us, and download this record. And
I am
you
an
can have
officer of the court.
Yeah.
I am an officer of the court. I have the right to access of court recordings. I'm an officer of the court.
Yeah.
And my client has rights.
Yeah.
Her rights are being violated. Look, there is, who do you call this person? Harry Nell,
Yeah.
sitting in a gallery.
Yeah.
I am refused to court.
Yeah.
That in itself is a violation in the highest order in terms of prejudice of my client's rights.
Harry Nell, my understanding is that he's sitting watching brief on behalf of the Meyiwa family.
And am I not watching brief? Look, if you paid attention, my brother, you would have noted that the advocate said they are watching brief in the gallery, but we will not allow the watching brief of Kelly Khumalo in court. Yeah. Why not?
Because Kelly Khumalo is going to be called to testify.
No. Many people. The list is more than 100. Does that exclude the fact, by the way, let me just inform you, and if you want this on record, it has been accepted by Advocate Baloy, by the registrar, by both parties, that I have been confirmed as watching brief and I will be allowed into court proceedings prior the instance of the court proceedings initiation.
Okay. Let's take a break now and come back. Magdalene, I want to give you more time. I don't want you to be pushed for time. So let me take a break and come back. And I want you to explain to me where did that confirmation and how did it come about.
I'll give it to you in writing.
Kelly Khumalo's lawyer, Magdalene Moonsamy, they're staying with us. Let's take a break. In Focus continues shortly. Welcome back and thanks for staying on. Still with us, lawyers of singer Kelly Khumalo, Magdalene Moonsamy, explaining to us, of course, their reaction to why they've been denied the status of watching brief in the Senzo Meyiwa murder trial. So you're saying you've got confirmation from Advocate Baloy. When was this confirmation given to you that you would be watching brief?
Halala. We had this confirmation. I will send this to you. It was prior to the trial. So there was no contest, even from counsel, for the defense. Yeah. This was sealed and confirmed. Yeah. All of these latest revelations are very nefarious.
Was this before the appearance of the second docket, which implicates your client?
Way before.
After?
Before the trial even started, my brother.
So with things now having changed and your client possibly being called to testify, you don't think that it presents different kind of circumstances and would somewhat not be appropriate for you to sit on behalf of your client if she's going to be called to testify?
What do you mean? I don't follow.
I'm saying when you received the confirmation from Advocate Baloy, it was before. In fact, when I spoke to you, you said it was confirmed to you that your client will not be called to testify. Now things have changed. The conversation is your client might be called to testify. You don't think that changes the situation significantly because now your client will be called to testify for you to be watching brief?
Oh, look, absolutely not. We always prepared ourselves to testify. Actually, my client has been, and I've been consistent in terms of my communication on the issue. My client is waiting for her day in court. That is not in dispute. That cannot in any manner affect the prior, the process and the current and what may follow. My client wants a day in court. So the issue rise with the fact that when Advocate Baloy requested a consultation with my client, previous consultations which we adhered to consistently, when he requested it, we said, yes, when is it suitable? Okay, fine. He then said, no, there's no need for it. You won't be a suspect. You're not a suspect and you won't be a witness.
Yeah.
He called. It's on email.
Yeah.
And then we were perplexed.
Yeah.
Because we were now pushing, okay, he wants this consultation, boom, 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 boom. Next thing, no.
Yeah.
You're not a suspect, you're not a witness. There's no need for us to consult.
Yeah.
My issue is the same senior prosecutor says in court that, no, we don't want whilst there's watching brief in the gallery. Now, my issue is the following. Watching brief. I am particularly isolated not to enter the court, but you have watching brief for other individuals in court.
Yeah.
That's prejudice. That's bias.
Yeah.
My client has never. Look, the issue with Baloy, and Baloy can, if he wants to be honest, he has asked we conceded, then he said, no, you're not a witness, you're not a accused, you're not a suspect, you're not a witness. We don't want you. We are prepared. I can send you the emails to confirm. We are prepared to go into a consultation. Boom. Next thing. No. So exactly. We're not affected. Look, we just want to follow court proceedings.
All right.
If the court wants to reject us, we have opted to utilize the process of the court.
Right.
We then have the right of recourse. What has been said, and I want to place this on record.
Yeah.
You have counsel that makes statements to the effect of, this will prejudice the accused. Now you tell me on count 3, my brother, when my client was affected from robbery and aggravated circumstances.
Yeah.
You say the accused will be prejudiced by the presence of a watching brief whilst there's other watching briefs sitting in the gallery. I'm not allowed in the court precinct. Now you tell me, what prejudice is that? Is this judiciary and this justice system? My client has never been afraid. We've always wanted our day in court.
Yeah. Magdalene, I'm completely out of time, so I'm unfortunately going to have to leave it there, but I appreciate your explanation and how you've expressed your point of view tonight. That is Magdalene Moonsamy, that is a lawyer for singer Kelly Khumalo.